I do have a prepared
my
statement
pleasure. Thanks for putting us on air.
that I'd like to read. And I didn't get a chance to present these things to the jury, so I am going to present them here right now. I love my country and am willing to go to jail, since apparently that is what it takes to get the truth out and restore common sense and freedom in America. As American citizens, it is our duty and right to hold responsible those who we allow to govern us by our consent. Oregon Water Resource Department, or OWRD, knew or should have known that our Oregon State Constitution in Article 15, Section 3 clearly states that every person elected or appointed to any office under this Constitution shall, before entering on the duties thereof, take an oath or affirmation to support the Constitution of the United States and of this state, and also an oath of office. OWRD knew or should have known that the Water Master is one of those offices, as well as any other office that had the authority to bring a citation against a citizen that could result in a criminal action. Because the citizens of Oregon would never have consented to be governed by any person that did not understand the citizens' rights and had not taken an oath to protect those very rights. But the Water Master, his assistant, and others did not have their oaths made or maintained in this case. They knew or should have known that this failure meant all of the actions taken against me were fraudulent and that they were impersonating officers and had no authority. OWRD knew or should have known that the wet season, winter runoff water, was never under the rule of appropriation. Historically, this was well understood, as well as it being defined by legal treatises and common law definitions. They knew or should have known the collection of diffuse waters does not trigger the department's permitting requirements because no appropriation occurs, which means they knew or should have known that their department had no jurisdiction on my pond water, and that in falsely applying that statute, they have denied me my right to the rainwater that falls on my property. OWRD knew or should have known that they were breaking the law when they granted 53 other landowners in the Big Butte watershed permits, exemptions, or waivers that were in violation, disregard, and conflict with the exclusive water rights that had already been granted to the city of Medford, which were to be used exclusively for municipal purposes under the 1925 Act. And they knew some of these ponds would be used for purposes other than municipal. OWRD knew or should have known that 36 of those pond permits were issued to landowners that stored rainwater, which was water that was the landowner's property right and not under the law of appropriation. They knew or should have known that 17 pond permits were issued to private persons who are diverting water from tributaries that are part of the Big Butte Creek. And they knew or should have known that several of these 17 pond permits have water sources listed as waters directly being diverted from the Big Butte Creek. In both instances, they knew or should have known they were violating the property rights granted to the city of Medford in doing so. It also means the OWRD failed to apply the law fairly and consistently and was blatantly discriminating in their actions against me and others. They knew, or should have known, that it was wrong to selectively prosecute any citizen criminally, especially when they had other less severe penalties to use as other options. They knew, or should have known, that breaking the law by violating my right to equal protection under the law was not justified. Perhaps the state was trying to establish case precedent on an expansion of the definition of a term that usurps the water rights of property owners throughout Oregon, like mine. They knew, or should have known, where rights are concerned, there can be no rule making or legislation which abrogates them. And that's from Miranda versus Arizona. OWRD knew, or should have known, that it is against the law to have a civil investigation ongoing and running concurrent while a criminal investigation or action is started on the same issue. They did so in this case. OWRD knew, or should have known, by doing this it could make individuals in their department as well as their department liable, in addition to causing the taxpayer tons of money by having to bear the burden of the legal problems that most assuredly will follow because of their incompetence. The judge knew these findings of fact and conclusions of law had fatal errors and should have dismissed this case, but instead, the judge denied me my constitutional rights to due process and ruled that the jury would not be allowed to hear any of this evidence, as he determined that it might unduly prejudice the jury against the state. Demonstrating his partiality and bias in favor of the prosecution, they knew that this was wrong. And the judge is always supposed to be impartial. The judge knew that the oath of office issue falls under the structuring issues in the law, and that he did not have discretionary powers on that issue, but instead he chose to use them anyway and rule against me, displaying further bias in favor of the prosecution. The judge knew that denying me my constitutionally protected right to counsel of my choosing was wrong, but the judge did it anyway. The judge knew that rushing me into judgment was wrong and in violation of my constitutionally protected rights, but he did it anyway. The judge and the prosecution knew that to try me on a null and void complaint was wrong, but they did it anyway, because neither the judge nor the prosecution could find the amended complaint on the day of trial, further violating my constitutionally protected rights. The judge threatened me with contempt and intimidated me repeatedly throughout the trial, causing me to lose my composure. In a fair trial by jury, the jury would have been able to hear both the law and the facts and would have used their constitutionally protected right to strike down an unfair law. I knew it was my right and duty as a citizen to stand up for my rights and for the rights of all of us. I knew that what the system was doing was wrong. I cannot in good conscience allow that to continue. Common sense is the basis for common law. Without common sense, the law is insane, and we did not agree to be governed by insanity or illegality. Our citizens throughout our history have laid their lives down, liberty and property on the line, defending these rights we hold and cherish. I'm sacrificing my liberty so that we can wake up as a country and stand for our liberty. Our campaign begins today. We invite every citizen that believes we can make this country better to join us and support this cause as we move through the court system up to the United States Supreme Court if necessary. so that we can establish once and for all that our rights are ours, not the government's. And that we will give our consent to be governed when those rights are honored and upheld by those we have entrusted to serve us.
All right.
Okay. Any questions on this?
Gary, the name of the judge?
What was the name of the
The name of the
judge?
judge.
The 30-day sentence, so that comes just
Timothy
after
Gerke.
he...
Gerke?
Gerke.
Or was it
Just tell them I'm shooting video for you.
I guess I need to put you on notice that I am wearing a hip brace. Okay, and it says here, Gary is at high risk of another dislocation of his left hip in any uncontrolled environment such as jail. Recommended delay in the sentence until the 1st of March 2013. Limit risk to his unstable revised hip joint. And this is from Paragon Orthopedic Center and the doctor's signature. Oh, you don't have the power?
Empowering it's already established, it's through our 501c3 foundation.
Okay, thank you.
And they can go directly. See you in 30 days.